Ladies and gentlemen, in the Dred Scott decision in the late 19th century, an 8-1 decision was made where all the judges were over the age of 75 and had been on that panel for over 30 years. And what they said was that African Americans did not have equal rights. It was the first interpretation of the 14th Amendment, and they clearly said that African Americans don't have those equal opportunities. It took over 70 years then for the Supreme Court to even hear or have the ability to overturn that decision and finally make that decision. It was when Brown versus the Board of Education where African Americans finally got the rights they so longly deserved. The rights that everyone in society, or the majority of society, agreed with because that was reasonable. It was over 70 years, and for many of those years, when people thought it was reasonable, they weren't able to get those rights. So what do we stand for on the affirmative? We stand when the balance is struck in regards to the evolving societal nature, while also the legal understanding when you have an entrenched constitution. Because holding a position for 30 years means you do not have the same understanding of the reasonableness that happens within society. Because the fact of the matter is, the Constitution or any document is a living document. And those ways we look at it and the values we attribute to it are different when society changes. So what do we really affirm in terms of model proposed? We said the same confirmation process will exist as it does within the status quo. The judges will have one term. That term will last for 8 years. It will allow them to make a change, and to make a change and be on there for a certain period of time. We think, yes, it is an arbitrary number. We also think the current process of death is an arbitrary process as well. So therefore, within that, we allow them to have some sort of say over that period of time. We think with the current justices that we have, we'll have some sort of incremental change where they will slowly get moved on and we'll look to appoint new justices. What do I want to talk about in substantive? Firstly, I want to talk about what the role of the court is in regards to interpretation of certain documents and certain legal norms. Secondly, I want to talk about the problems we see under the status quo. And thirdly, I want to talk about why the affirmatives create a better process and engagement that exists when we have such a model. So firstly, let's talk about what is the role of the court when it comes to interpretation. We think norms do change. We think when we have these norms, modern norms, for example, have developed over time. For example, freedom of speech. In the 1950s, it was discussion in regards to shouting fire in a cinema counted as freedom of speech. Where freedom of speech is now is the decision which we saw in regards to was it ever, is it legal or is it valid for someone to pass themselves off as a soldier? And is that an infringement on freedom of speech? That's how societal norms change and some of the basic freedoms we give within the Constitution. But when it comes to interpretation, I think the old judges are isolated. But what has happened over the last decade, because we have within the 8-year period, that any decisions made is that over the last decade, they've been intrinsically involved with the community and they know how societal norms have changed. Because the current Supreme Court's justices live in a bubble. We call it the Supreme Court bubble. But these people live independent of their lives. When their clerks say the judges aren't interested in reading media or talking to people, or that opinion they gain from constantly seeing cases, just the basic day-to-day interaction with people doesn't exist when you're on the Supreme Court. So therefore, their interaction with the wider mass of society is limited. So the ability to truly understand what's happening and those norms change don't exist. Because when you can allow people like Nixon and Reagan to still have an influence on the Supreme Court, it allows the dead hand of the past to still have a role in cases decided today. The legitimacy of those decisions is taken away, and we think that's harmful. But let's look at the problems that exist, and I think you've already got an idea of them. In regards to the current incentives that exist, we have an incentive for courts to appoint people who are young. Why? Because you want to maximize their time that they can stay on the court and that they can influence. If you're lucky enough as a president to suddenly have 3 justices passing away, then you have the ability to change the dynamics of that court for not only the next decade, but for the next 40 to 50 years when we have no idea of how societal norms or the ability of people to actually change and understand that exists. We think that's the fundamental difference. Because when you have the ability of judges even in regards, when we talk about the earlier decision in regards to Dred Scott, when even post-civil rights decision, there is still the ability. But also, it's the ability for processes to decide certain cases in a certain way. Because in example, when it comes to deciding an original decision, when it comes to something like gun control, we think when we allow the interpretation of certain things in certain documents, when the civil procedure and the majority of Americans call out for gun control, but we still have justices in the old system and the old thought process that we don't need it. In the case of the District of Columbia versus Helena, we saw that it's still allowed for guns allowed to be near schools. We think that's inappropriate. We think those are what's happening when you have certain conservative judges. We think the same thing might happen with liberal judges, and those issues might exist in this burning point. We think we strike the right balance, because you're constantly overturning and constantly changing the nature of those people. So we think that's important. But also, in regards to respect for precedent, you think that when you're going to make a decision, you want your decision to last. Because at the moment, when we see justices not caring about precedent and overturning willy-nilly, they know they can, because they control that court for the next 30 or 40 years. Because if you want your ability to be remembered, or for you to be judged as a legal independent or a legal mind, one of those greatest minds, then you need to respect those precedents and create proper law that is structured and developed. So we think that occurs. Let's really look now in regards to why we get better process and the ability that happens there. First, like I mentioned, these people are involved more recently. They understand the nature. They also are more likely to write and explain the decisions with greater nature and the context of that decision. We saw in Lawrence versus Texas, when Justice Scalia probably wrote one of the most homophobic decisions that you could possibly ever read and that existed. They said that homosexuals do not have any rights. They don't exist to have rights. Their ability and their choice of their sexuality or how they are, that human being that they are, doesn't allow them to gain any rights that exist. We think he knows, because he's on the court for that period of time, that whatever decision he makes is probably not going to be overturned for the next 30 or 40 years, and if the way the courts are still going, and if luck plays aside for the conservatives, and that the next justices pass away when there's a Republican president, that therefore that decision might stand for a lot longer. So that decision changes. The context and the reason, the ability for the people to interact with that changes as well. Because you don't respect those decisions. You don't allow people to actually engage with that. Why? Because those people who are supposed to protect their rights or protect their liberties and to act as a balance check for the legislator doesn't exist. Because you don't trust them. You don't have their ability to put that same faith in them when you read decisions that are homophobic and changes anything that you thought or you're instilled in that values of the United States of America that doesn't exist. It's that interpretation that is fearful. But also it just gives a blatant moral hazard for certain justices to stretch out their time, or when to retire, or when to, pass away and have control over that. But even then, we think that exists. We think those moral hazards exist for them to want to get rid of, to leave when there are certain biases in regards to certain presidents. Ladies and gentlemen, because I've told you that documents are living things and their context and interpretation change. That the ability of the dead hand of the past to control the cause is problematic, and the affirmative team are very proud to oppose the motion. It's a beautiful morning.
Mr. Speaker, Dred Scott was a bad decision. Homophobia is bad. But there is no reason why in racist 19th century America, term limits would have changed anything. In fact, we say in instances when populaces are actually homophobic or actually racist, when you have term limits, you entrench the power of a particular president to appoint judges who institute the sweeping change by 9-0 majorities. So we question why any inherent links between their plan and achieving what they thought was progressive social change. Few points of rebuttal. Firstly, is high turnover necessary for adaptation to change? The first thing to note here is that judges don't live in this weird vacuum. The mere fact you're on the Supreme Court doesn't mean you live in your car and close your ears all the time and don't go outside to see the air in case you get shot or whatever. You can still progress with social change. But importantly, they've misconceived the nature of the judicial role. We think the separation of powers means that the judicial function isn't actually about responding to their conception of political change. We think judges are actually in that great a position to make an assessment of what exactly 51% of the population wants. That's a misconception of how they're meant to function. But furthermore to this, ladies and gentlemen, we heard that the status quo gives excessive power to presidents to shape decisions well past their death. We think, ladies and gentlemen, the problem with their plan is is it gives a sitting president a huge amount of power to shape the court because of the guarantee of term limits kicking in. We think it's ridiculous that a particular president who may be elected for 2 terms or 8 years can literally appoint the whole court, ladies and gentlemen. I think that's a huge amount of power, particularly when the populace doesn't vote purely on this particular issue. So we think it's illegitimate for presidents to have that much power and massively overrides any constitutional limits on power. We accept that under the status quo, presidents may have accidental power to shape the court, but we think that's not inevitable, and we should try and limit the extent to which they have this power as much as possible. Secondly, in terms of the implications for judging, we have this weird idea that judges were more likely to do things like respect precedent under their side of the house. But we think, why is that the case? If you've got 8 years to shape your legacy, why wouldn't you overturn as much as possible? Why would you write massively overreaching judgments just to try and entrench your influence and the fact history will remember you for that? We think that was pathetic analysis. Alright, pathetic's me, I don't mean that. The likelihood of bad decisions. So there's nothing inherent about life tenure to racism or homophobia. And just to the extent they can pick out bad decisions like Lawrence in Texas, we can pick out good decisions like Brown Board of Education. No one wins that battle of different judgments, right? Let's actually look at how these things really play out. We think you're more likely to have moderate judgments when you have to build coalitions over the long term. We think the reasons that Republican-appointed judges like Sandra Day O'Connor and David Souter were quite moderate in each individual judgment is over time they had to build coalitions within the court for their preferred judicial philosophy. We accept that Justice Scalia is a bit of a crazy person, but that's ultimately, we think, under a life tenure model, when you have to work within the institution and build capital over time, you're less likely to resort to extreme, harmful decisions. Their plan entrenches power in particular actors. So 3 points of argumentation at firstly. Firstly, the judicial independence requires life tenure. Secondly, that term limits lead to inferior judicial outcomes. And thirdly, term limits unduly politicise the appointment process. So, why does judicial independence require life tenure? We think judicial independence is a critical principle in this particular debate. The judiciary is essential because of its capacity to act as a check on the power of the legislature and the executive, which requires the highest possible insulation from political pressures. Ultimately, the role of the judiciary is to say what the law is, and that's a huge amount of power, particularly in a constitutional complex. We think for that reason, you need to minimise political influence as much as possible. We think it's undermined by the opposition's case. We recognise that under the status quo, there is some political link between the presidency and the judiciary. Obviously, at some point, presidents have to appoint judges. We think we limit that as much as possible under a life tenure model. We limit it only to the extent where it's absolutely essential because someone has carved it. And there's a good reason for that. Because we think we need to ensure that the apolitical nature of the institution is maintained. The way you do that is by constructing the discourse against viewing the Supreme Court as being political, right? So against viewing the idea that individual judges are basically these raging Republicans or raging Democrats that only want to impose a particular social view rather than performing the role of performing the judiciary. So we think when we limit the extent to which this turnover occurs and we limit the extent to which people have power to appoint these judges, that limits the extent to which that political influence alters that discourse. But the second argument, why do term limits lead to inferior judicial outcomes? We think you do a number of things through the opposition plan. You change the judges who are actually appointed. So if you're President Obama and you know going into your first term that healthcare is going to be your main game, why would you appoint a judge on the single issue of knowing that they're going to actually uphold the individual mandate, right? We think that's incredibly problematic because you don't need to think long term about the credibility of that judge and the extent to which they will have an appropriate judicial philosophy. We think that's problematic. We think what's much better is under the status quo when you need to think long term beyond your particular presidency, because then you can actually factor in how that judge will act over time, how they'll respond to a range of different issues. And the key thing to note here is that the types of issues on the judicial agenda are often very unpredictable. So we think the problem is that when you appoint judges on particular agendas, you limit them. The second thing you have is less experienced judges. We think what happens under the opposition plan is you exclude judges who are reaching their prime, who've had enough time in the court to understand the judicial philosophy, to apply it in a range of cases. We think that's a problem. What you also get is less moderation. We think what's been great about the US Supreme Court is a range of Republican appointees, like O'Connor, like Stevens, like Souter, have moderated over time. Over time, they've come closer to the centre on the basis that they've interacted with other judges, they've modified their judicial philosophy, and have tried to build coalitions over issues in the long term. We think you get less moderate judges and the opposition plan more of an incentive to elect partisans. What does that mean? that reduces certainty. We think you're more likely to have judges that basically come in and uphold a key issue in the president's agenda or overturn that issue without the certainty about particular issues like the Commerce Clause that apply over time. That's bad for the rule of law. We think, further to this, ladies and gentlemen, we think this is harmful in terms of the way the judiciary acts. We think the judiciary will always have an incentive to build their legacy. There's always that impulse. But that's heightened when you have an accelerated time frame to do so. So we think Chief Justice Roberts was less likely to uphold Obamacare when he knew he only had 3 more years to shape his legacy as a Republican appointee. So to build his legacy, you have to make a big decision with big political consequences that people remember over time. We think that distorts the judicial function. It also changes the kind of cases that actually come forward. You're more likely to allow cases to be heard in the Supreme Court which are more politicized and on areas that you're particularly interested in. Even if they're not the best cases for judicial resolution, even if the issues raised aren't appropriate. We think that's a distortion that's harmful. Thirdly, term limits unduly politicize the appointment process. We think it's problematic when under the opposition's plan, you can know that a change in tenure is coming. You can plan election ads around the fact that a particular new judge will be appointed. We think that's problematic because it explicitly politicizes every single appointment. It forces presidents to issue an even more extreme litmus test for who they would appoint. We think that undermines the legitimacy of the court. The Supreme Court isn't perfect, but it still has the highest level of credibility of any American institution, ladies and gentlemen. We think when they're less likely to be seen as apolitical, we reduce the acceptance of any decision that comes forward. That's a problem. So ultimately, there's nothing inherent about term limits and racism or homophobia. What you do is pervert the judicial process. That's why we oppose.
Mr. Speaker, if you believe that it's not the role of the court to respond to changing social norms, to consider the impact of rights in society, you should be principally opposed to a Bill of Rights. The reason being that rights have to be determined in the particular context in which the case is decided. So when you have a decision being determined by, say, Justice Stephen Breyer, who was appointed under Bill Clinton, in the modern day, that is not in accordance with what is happening in the world at the moment. That's the essential problem we brought to you in Sharm's speech, and we had no real response from them apart from the fact that judges need to be politically independent. And somehow the status quo, you get these wonderful moderate judges who are not politicised. Wow, that was laughable, Kieran. I thought you would have known that. 2 points of rebuttal. No, shame on you, Chris. Firstly, what is the role of the court? Secondly, do we get better decisions? I'm going to deal with Kieran's material about confirmations because that's my first point of substantive. So, in terms of the role of the court, we heard firstly that in response to Sharm's material that yes, it's bad that presidents have some role in controlling what's happening in the future, that over 30 years it's a bad thing, but we make it worse because somehow over 8 years they're just going to appoint the entire court and that's going to control precedent in the long term. We don't think that's true because obviously we don't think all judges are going to be appointed at the same time. But the second thing we'd say here is the problem they never recognise is that when you have judges determining things that happened 30 years into the future, that's really bad for those sort of things. In terms of having racist and really homophobic societies, yes, it is bad when you have those things and maybe you're not going to get good court decisions in the short term. But when you have a justice that's going to protect their legacy by holding on to those decisions for 30 years, it makes it affirmatively harder for democratic processes to respond to those particular things. So when you have an 8-year term, you can have coalitions building against decisions that are really politicised. People can respond to those things and presidents can be appointed in the democratic system to respond to those particular issues. If you believe that rights are to be determined in the context of now, and they never gave us a reason why they shouldn't be, you have to follow our plan. Because it's totally illegitimate for President Nixon to control what happens into the future. Whether that is a conservative or a liberal justice is not the point. It's the point that they are determining what is happening and they've got 30 years to do so. But what did Kieran mostly want to talk about? The fact that you're going to get bad decisions and worse judges. What we heard is there's going to be less respect for precedent under the status quo. I'm sorry guys, if you've read any of Justice Scalia's past decisions, you know that he is ignoring precedent willy-nilly. In terms of the most recent case in Obamacare, ignoring precedent in which he said just 5 years ago that the Commerce Clause allows people to criminalise the growing and selling of marijuana. Why is it worse under their model? Because over 30 years you know that you're not going to have control of those ideas and you can shape it into the long term. In an 8-year term we know there's going to be political responses and more judges considering these issues. You're more likely to respect precedent because it's incremental and less likely to be overturned. When you have a 30-year tenure on that court, you don't care about the future impact of precedent because you are going to set what precedent is in the future. That is really silly. Secondly, in terms of moderation, maybe Justice Souter and Saturday O'Connor did protect abortion rights. That happened 30 years after Roe v. Wade was decided. Maybe that's not the best way to determine rights in a democratic system. But the second thing we'd say here is that the response from political forces has been incredibly extreme. We now know that most of the Republican judges who have to be appointed whereby Republican presidents have to pass people who would strike down abortion rights. The central mistake they made was they didn't check carefully what Souter and O'Connor believed. When you match it up with the current day justices of Alito, Scalia, Kennedy, which kind of swings every which way depending upon the weather vane on a particular day, and all of the conservative justices like John Roberts, we think you get more ideologically extreme people because you're worried about the impact for 30 years into the future. Politicisation works for us. In terms of worst judges, we think you definitively get worst judges. Yes, Harriet Mears didn't actually manage to get confirmed. But the mere fact that they wanted to put up someone who was 30 years old, not actually a qualified justice, but would be there for the long term, was really, really damaging for the court process as a whole. John Roberts, yes, was able to, craft his legacy really carefully, but we think he's effectively changed the meaning of the Commerce Clause by stealth. If you look at his recent decision, yes, he didn't strike down Obamacare, but we think that he's not going to take his legacy by making really, really politicised decisions. And if there are really, really politicised decisions, people can actually respond to them. That's the benefit of our system that yours doesn't get. Under your system, the only way to respond to politicised decisions is to actually hope that someone's going to die soon, you're going to get the right balance in the court, and you'll be able to change those things. That is rubbish. Okay, in terms of substantive material, let's bitchy now. 2 points. Why does this improve confirmation processes? It's going to respond directly to Kieran. And secondly, why does it increase respect for the judicial mandate and, of course, the Supreme Court as a whole? What do we hear from Kieran in terms of confirmation processes? We heard there's going to be even more litmus tests on Supreme Court justices. I'm sorry, if you ever looked at any Republican debate in which they all have to swear to appoint pro-life judges and they won't get funding and money from pro-life groups unless they do so, I think politicisation is probably a harm that exists under both models, but maybe under yours, guys. Why is it even worse under your system? Because if you don't get the appointments of the judges right, you lose that capacity for 30 years. That's why John Roberts is now being called a traitor by Conservatives, or they called people like Sanford A. Connor and David Souter as traitors. So we think worse people actually end up getting appointed under your system, because you're more likely to appoint people who are ideologically extreme because you're worried about their impact for 30 years. You've got no opportunity to correct that particular mistake. We think that harms the judicial process as a whole. As I said in rebuttal, it leads to worse people being put up for confirmation. Someone like Harriet Mears, who was incredibly close to being confirmed despite having no actual qualifications, having never been a judge in the first place. All those things are really bad for decisions as a whole. We also think you get worse confirmation battles. Sure, politicisation is a harm that exists under both sides of this debate because everyone thinks that the Supreme Court is a political body. But ours is better because you've got more opportunity to deal with that in the future. You're a lot more likely to appoint people who are good judges. Why is that? Because you want their decisions to speak for themselves. You need over an 8-year period for the next 8-year term, the next justice to come along, for that decision to be valid, for that to respect precedent, so that other judges are going to say, in respect of the judicial role, we don't want to overturn those particular things. That's why it's actually going to be better under our system for confirmations, because it's going to be less ideologically extreme, and people are going to be far less worried about all those sorts of decisions being overturned for 30 to 40 to 50 years, depending upon how long the judges live and whether Kennedy manages to live for another 20 years and screw us all. So, secondly, in terms of respect and legitimacy for the court. The biggest problem we think we see that is independent of any discussion of a political independence, which we think we get because these judges don't have to really get more jobs after they become Supreme Court justice, etc., is that when the people feel that they don't control who's on the court, when they see people like Justice Scalia writing homophobic decisions about gay rights, even if it wasn't dissent in Lawrence and Texas, they don't feel any accordance with that court as a whole. This is actually a really big harm because distrust in the political system as a whole damages people's perceptions of democracy, their willingness to turn out for elections, or their belief that judges are making things that are actually neutral decisions. That's why even though the Supreme Court does have the highest approval rating of all US government bodies, it's still not a great approval rating because everyone hates and distrusts the US government. Things like Roe versus Wade have massively destroyed people's faith in the judicial process as a whole. That not only hurts like political decisions about individual rights, but other kinds of matters, decisions about what the relevant limits of various powers are, what the police can say in those particular things. So when you're trying to implement those decisions and change society as a whole, people are less likely to respond. In terms of Roe versus Wade, we now see a number of states have more restrictions on abortion rights because they don't believe the decision was made, they don't feel they had any control over the process in which abortion rights were enacted in the first place. Unless people believe they're able to change what is happening in the Supreme Court, that they have control, they don't respect the decisions, and they don't believe it's valid. In terms of Obamacare, we see at the moment a number of states are going to reject Medicare funding because they don't think the court has a valid role. They believe that it's a political decision that has been made by particular justices who were appointed by Republicans, and John Roberts was apparently now a traitor to the conservative movement. That means that you don't get long-term impact and long-term belief in the validity of those decisions and in the court as a whole. Those are concrete harms. Mr. Speaker, we haven't heard a reason why judges who were appointed 30 years ago can determine modern day rights. If you want a Bill of Rights that has rights in it and you want those rights to be respected and to be determined according to what is a modern day thing, you need to have continuous control over justice by the political sphere. That's why we're very proud to propose.
Ladies and gentlemen, it concerns me that the affirmative team think they're the team that stands for protecting the civil rights in this debate. Because let's look at the consequences of implementing their model. If Romney gets elected, on average in one term, he'll have the opportunity to appoint 4 justices. Some of those will replace Liberals. It is very likely that the consequence of that would be the overturning of Roe v. Wade. You think Brown would have stood through Reagan's term and 2 Bushes? You think those civil rights movements you stood for would stand up to those presidents who didn't like them? Who were handed the opportunity to over 8-year terms and systematically overturn those through the use of the Supreme Court? You're not the team that stands for civil rights in this debate. Sometimes slow and steady is the only way to guarantee those things aren't reversed. It doesn't mean we like the status quo. It doesn't mean we like the level of politicisation that already occurs. It doesn't mean that if you handed me a revolver and Antonin Scalia, I wouldn't seriously think about it, right? But it doesn't mean that that's a good solution. And they've ignored all of the problems they create for their court. I'm going to talk in my speech about what they do for lower level courts and litigation within them. I want to deal with 2 points of rebuttal first. Firstly, does this lead to better decisions? Secondly, what does this do for politicisation? The affirmative team said in terms of better decisions that it's about making them change with the times. Kieran told you what the cost of that was. They became beholden to legislatures and presidents who wanted to appoint particular types of people. They decided who they appointed on single issues and single determinations of what was important to that particular presidency at that particular time. That led to unpredictable courts when legislation that wasn't predicted to come up for review did, and you had appointed your court members on the basis of what they thought about healthcare, not abortion. That was a real problem. But secondly, we reject the idea that social change happens so quickly, so radically and so unanimously, that the only holdovers post-Brown who still were against African American rights were a handful of appointees by those types of presidents who didn't. There were a large number of people in society who wanted to wind that back. There were a large number of people who didn't like those changes. And you handed them the power, if they managed to win the presidency, to undo all of that. And presidents who would have considered doing that have been elected since. So you made social change beholden to legislatures that you seem to think were pretty bad at protecting them. We thought that was problematic. We thought it was particularly likely, for instance, to lead to the overturning of Roe v. Wade. But it also ignored all of Kieran's material about this. Secondly, does this politicise that appointment process in ways that are problematic? Kieran told you it means you can pick your judges to dominate the single issue that you care about. That you can plan out your legislative agenda and pick judges who will support it and who will defend it in the ways that you care about. Ashby's response was that currently all they do is appoint 30-year-olds so that they can dominate the court for another 50 years. Firstly, they're not appointing people that young. But secondly, the rarity of Supreme Court appointments means that the public and the legislature view them as particularly special. It means they are particularly likely to reject that politicisation in ways that they don't reject other political appointments. People are far more likely to reject a SCOTUS appointee than they are to reject an appointee for Secretary of State. The examples of that being people like Harriet Mears and Robert Moore. That the public are willing to turn against this, that the legislature are willing to fail to back the president when they're appointing people who are vastly inappropriate. But when you make this a routine appointment that can be fixed 8 years down the track, you make it much more likely that people turn a blind eye to that or choose not to fight on that particular issue. And the fact that it is predictable, the fact that you know that in 3 months' time one of these justices will be retired, you know which one, and you know that you have an opportunity to replace them, means that you can plan your political credibility around them, means that you can build up political capital to use to appoint the type of political appointee that you want in a way that you can't do when one of them has a heart attack. Callous though that sounds to say that. You're constructing a world in which Republicans already view O'Connor and Stevens as mistakes and already want to change that and already want to avoid appointing people like that, and you give them every possible opportunity to sway the court in whichever direction trying to rush it through, or deliberately trying to seek a split amongst the circuits, is fairly minimal. Because you know that as long as your case gets there in the end, the decision is likely to be the same. The affirmative team drastically changes that. The increased fertility makes it more likely that waiting actually does lead to a change in outcome, and perverts the judicial process all the way down that chain into lower courts. Let's talk about this. Firstly, in lower courts, in terms of litigators, there is an incentive to delay or rush through your hearing to get the exactly right timing when you know that a justice who is particularly favourable to you is about to retire, or one that is particularly unfavourable to you is about to retire. That leads to massive abuses of process as people try and rush through their case or delay their case or deliberately disadvantage their opposition in that case in order to try and get the best possible outcome for them in terms of what they see as an inevitable review by the Supreme Court. Or worse, you create an incentive to argue in ways designed to split the circuits of appeals and make it more likely that the Supreme Court will take up your case at a particular point in time. Or even worse, in an attempt to get a bad decision that is likely to be overturned by the Supreme Court because you think that the circuit that you are currently in is unlikely to be favourable to you, and your best bet is to make that decision look bad and make that decision look needing of review. That is incredibly problematic for the way cases are argued in lower courts and causes real perversions of justice, even in cases that don't make it to the Supreme Court, which we think is problematic. That is also true for the judges themselves in those lower circuits who have opinions about the way the law should be interpreted or should be designed. Again, there is an incentive for them to either rush or delay in an attempt to make sure that their case is considered for review by the right justices of that Supreme Court, or for that matter, to place small target on controversial issues where you don't think that you can wait out long enough to get the right type of court. You have an incentive to make your decision and frame your decision in a way that is as marginal as possible to avoid it being taken up for review. That is incredibly problematic for the way those lower courts operate. But finally, it introduces an element of lobbying into the appointment of those Supreme Court appointees that is incredibly problematic. The incentive for a company that doesn't currently have litigation on its way to the Supreme Court to lobby for a particular appointee is actually quite low, because very few people regularly go to the Supreme Court for decisions, whereas everyone is regularly affected by legislatures or other types of appointees. So at the moment, there is very little lobbying about who goes to the Supreme Court. But when you currently have a case before the Supreme Court or on its way to the Supreme Court, the affirmative team creates an incredibly high likelihood that those people will turn to lobbying in an attempt to influence who is appointed in ways that are problematic and in ways that bias the court even worse, by that lobbying trying to make sure that their particular issue is the primary thing on the President's mind when they choose their appointee. You politicise the judicial process all the way down the chain of judicial review. Ladies and gentlemen, the affirmative team is right about one thing in this debate. Partisan appointments that turn courts into proxies for particularly lucky presidents are dreadful. Scalia was a dreadful appointee, and if he genuinely wants to behave in the way he does, he should resign and run for the Senate rather than pretending to be a judge. But we are even less excited about a proposal that guarantees a two-term president total control of the court they operate. The one saving grace of the proxy war of appointments created by Roe v. Wade is that they are balanced out president to president. They end that. We think that's a disaster.
Mr. and Madam Speaker, what we had today, ultimately, was a very schizophrenic case from the negative team. To one extent, they wanted a highly democratic system in which, ultimately, social views reflected the ultimate laws that were passed. But at the same time, what they stood by today was a situation in which Justice Scalia would not rule for just 8 years, depending on when people realised that he was a fuckhead and should leave, but rather rule for 40 years in which he gets to hold the court to ransom, where he gets to decide and hold his homophobic views even when the rest of society has moved on beyond him. The ultimate fact was, Mr. Speaker, that they need to show in this debate why any individual should be able to decide the fate of an entire country even when the rest of the country views that his interpretation of rights are so backward and so in a situation where they do not reflect any sort of social norms. It's because of the fact, Mr. Speaker, that ultimately the laws aren't just like a set of words, but rather are things that need to be interpreted to match this day of social day. Okay, so let's take a look at the three issues in this debate. First, what is the role of the court system? Secondly, what leads to more independent judiciaries? And finally, what engages the public more effectively? Okay, so let's take a look at this first idea of the role of the courts. So what they wanted to run effectively in this debate is that, like, disengagement by the courts was a very good thing. And it was better when judges didn't have to worry about what 51% of individuals wanted, right? But the problem with this is that we've got 4 responses. First of all, it's not about conceding necessarily what the 51% or the 52% or what a certain group of individuals want. Rather, it's about understanding that the Commerce Clause, which may have in the past only been relevant in terms of like shipping your caravan from one state to another, but is rather in terms of like defining Obamacare and that individual's right to healthcare and stuff. So as a consequence of that, right, given that constitutional rights necessarily apply in a situation that is very different every single time, it is very important that when they are necessarily applied, they're applied in a manner that the democratic mandate of the individuals most likely reflects. But more importantly, right, our second response to this, right, is that this debate wasn't a choice between like fully disengaged judges or like judges which were elected completely under our system, given that it wouldn't be true, given that it was like incremental insertions, right? The choice was between that, given that disengagement is important to an extent, where do we draw the line and what strikes the balance best? What they would push under this side is to ensure that judges who necessarily were appointed by Nixon would then have a choice in deciding the future of like 20 Americans who didn't believe that homophobia was correct, who didn't believe anymore that, say, the individual mandate was not so much of a bad thing, who didn't believe anymore that those individuals should be oppressed by the state in such a manner. You see, what they would ensure under their system is the entrenchment of negative social norms. Because while they wanted to run on this side of the house of how like social norms would be entrenched due to like these overturning battles, what entrenches negative social norms is when you empower one of the most powerful institutions in the state to say that homophobia is a valid position due to the Constitution. That's the problem that you get us in your state, because you create a cyclical effect where those negative social norms are constantly reinforced by your system. Okay, so given then that we've established that the role of the judiciary is necessarily to ensure that the public feels as if it is most relevant, what then ensures that it is most independent and least politicized as ever? Okay, so what they effectively ran in this is that it's very important that the good thing about having a long 30-year, 40-year period is that you wanted to build your legacy, and as a consequence you'd be willing to build coalitions and you'd be willing to do certain things to ensure that you would build a legacy that would ensure into the future. The problem with that is that it rested entirely on the assumption that the judges were doing that in the first place, right? When it is empirically untrue, given the cases that are currently presented, where judges were actively selected to oppose these based on like very pernicious reasons that absolutely had no real legal grounding. The difference that occurs under our system is that given that judges have to work within a legal system where you have to provide valid reasons for that decision, when you know that you only have 8 years necessarily to exercise your rights, what you would necessarily do in that situation is you will create the most effective and most logical, strong reason to ensure that your decision survives beyond your tenure. But more importantly, right, you're just going to select more experienced judges, because under their model, in which you have like you keep your position unto death, what that necessarily leads to is the selection of judges which are extremely young, as opposed to selecting experienced judges who most effectively understand the legal system and hence are able to ensure the legal system is most protected. That was what we told you, that was never ever responded to by the negative team today. But more importantly, right, we also say that in this state, that you actively politicize the judicial system more effectively more negatively under your system, because of the fact that you are selecting from the beginning and you are forcing all political candidates to take a particular view that lasts for that position. That was logic we told you about how like all Republican candidates to this day still have to promise that if any Supreme Court judge dies, they necessarily have to choose one that is pro-life. So what you do then is that you get a negative social norm that may have existed 30 years ago to continue to permeate to the modern day. But finally, right, their characterization of how you get like this overturned battle in which like judges would get elected and they'll remove those particular laws, or they'll claim that particular laws were ineffective. We would say, firstly, we don't mind that, even if that was necessarily the most horrible situation that they could live. Because if the public so strongly believed that something was so wrong, it is no position for the judiciary, which is so disconnected from the public, to decide on that basis, given that we established at the beginning of this debate that the role of judiciary was to interpret laws, but also interpret them in a manner that the public felt was most relevant. But secondly, right, we just don't think that's necessarily going to happen, purely because of that like was our model, that you would get like incremental insertions of those justices. So while Romney could come to power and put in 4 that could maybe want to overturn the individual mandate, or overturn like don't ask, don't tell, when you have 5 other judges which are also appointed by Obama, you get that balance right in the end anyway. But our final response to this, right, is that all their claims that they brought out in second speaker about how like you would get like selections of particular like cases as opposed to others, we just said that that's empirically untrue, given that you have a system which is very systematic in selecting those court cases. It isn't up to the out of their folder and files. So all of your logic necessarily was not true just because it was empirically not the way in which we selected those things anyway. Okay, so on to this final issue of political engagement. What they wanted to run under this issue of political engagement and what we get the public person side is that what we would ultimately get is a situation in which there would be massive amounts of lobbying, where groups would actively advertise to select particular judges over others, where elections would ultimately become about deciding judges rather than deciding policy. Now the first problem we had with that was that ignored the reality. We're already under the system of the status quo. That was already happening when you got massive lobbying in terms of judges, when you got massive amounts of deciding about whether or not that judge should be a particular position. And we've already talked about why it's more problematic when you get an atheist system, because you force those norms to be permeated into the long term, right? But the second problem is that the reason why it's worse under a system in which you have such long particular situations is that you actively disengage the public when you have a court that acts against what the public's interest is. But more importantly, it changes the political discourse when you have judges like Scalia and stuff are actively claiming that particular social views are valid because of the Constitution and are valid because they say so. But finally, right, we say that the lobbying is far worse under your system and in terms of advertising. Because in their system, right, such as in the case of the Romney campaign already, where it's well known that one of the judges, which are more liberal, is likely to die. Romney is already campaigning on that basis of how it is very likely that certain judges could die. And as a consequence of that, he has valid reason to get into power to overturn those decisions. But more importantly, we also said that you affect the public discourse when you actually insert leaders who then can continue to say those negative things for the next 30 or 40 years. Mr. Speaker, it was ultimately true in this debate that the court system could never be entirely disengaged from the public. The most important thing then to ensure was that when they were engaging in public policy, when they were deciding what was the right thing to do, they weren't deciding on the values of yesterday or the values of today.
Mr. Speaker, the real swinging motivator in this debate has been the affirmative stance on precedent. Sharon's got up and lamented the 70-year-long precedent of Dred Scott, and then at various times this team has bemoaned Scalia's refusal to uphold other precedents. We would think, if anything, a refusal to uphold precedent is exactly what the affirmative side wants. Yet they can't get clear in their head. Do they want judges who are going to overturn bad decisions, or do they want judges that are going to follow precedents? Because you can't have it both ways in this debate. And equally, you can't just stand up and be the team that opposes Justice Scalia as though that was going to ever be some sort of controversial position to hold in front of the court. When a president is given a certain number of appointments, not by virtue of when somebody dies and that sacred burden falls upon them to make that decision on a case of accidental or uncertain reality, but when you say that at the start of your presidency, you will know that you will appoint a certain number of people within that term, and they are your appointments. They're guaranteed to you. No one can take them away. No beating heart or new form of cancer treatment can deny you the right to appoint a particular justice. That's when you see people start to appoint their men and their women onto the court to ensure that they get their decisions for those 8 years, because that's their right, given to them by the fact that that appointment came within their term. And that was exactly why you didn't get the type of backlash against Scalia that we've seen now, where people are unlikely to support that type of radical justice again, when he is one of the most unpopular justices on both sides of politics. Because he's seen as destroying the independence of the court, because he's seen as taking a political role, because he's seen as dragging that court to the right. That perception is not there when that political character of the appointment is celebrated by the very process and the very structure of the court. So after that introduction, 3 questions. Firstly, do all judges make bad decisions? Secondly, what is the impact of term limits on judicial independence? And thirdly, the perception of the court. The affirmative side says these judges live in a bubble and don't experience social change. 3 responses. They do not live in a bubble. They watch the news. They experience the world around them, no more or less than other people that age or of that wealth or in political life. Secondly, newer judges are no less in a bubble. They've still been judges mostly. They've at least been rich. They've probably lived in Washington, right? They're not going to get people that are any less in a bubble. Third response, we don't want them to try and guess public opinion. They do not have the capacity to measure what the public thinks about a given issue, and to try and do that by talking to their driver more, or trying to remember what happened in their last 2 years before they got appointed, is a poor mechanism for gauging what the public wants. It is not their role to carve the Constitution as according to some misguided attempt to guess public opinion. That is what you want a government for. We then heard that they're going to write homophobic and racist decisions because they know they'll still be on the court, right? Scalia was on the court for only 8 years when he wrote his position in Lawrence. He was in the minority. That minority is getting smaller, Mr. Speaker, and that's the harm that he faces. If you write a crazy decision, you're going to be forced to have to try and justify that in the decisions you give now and now and now. And he gets seen as a terrible judge for having to try and worm his way out of the crazy decisions he wrote earlier. Judges that are only there for 8 years don't have that problem. In fact, they have a greater incentive to try and say as much as they possibly can in those 8 years. That means they take the cases that will allow them to say them, not the cases that need those decisions most. It means they will write the type of judgments that can be used in the future, that will be noticed and that will get them a reputation. They don't have time to craft a legacy subtly over time, as has been done by Roberts. The affirmative side recognised that he cared about his legacy. He didn't want it to be a politicised verdict. He didn't want to bring the court down with that decision. That's exactly the type of evolution we wanted to celebrate. The type of evolution you got when people weren't a political appointment for 8 years' time, like a mere president or a mere politician, Mr. Speaker, but were a position entrusted for life where their job was to construct the Constitution and understand and interpret it according to their own particular philosophy. We thought that was a conceptualisation that best empowered the decision-making that we wanted on the court. And that they wanted, for that matter. So secondly, what is the impact on term limits on judicial independence? The negative side told you that the power to appoint judges had to be held by somebody, but it needed to be rare and accidental power, not one that you can plan for, not one that you can politic for, and not one that you can have a guarantee and characterise as being your own domain. We heard from the other side of the House that judges cast their power after the end of a presidency, and that Nixon's dead hands, God forbid, can come out and molest us from the past. That is still going to happen. Like, you can appoint a person in your last year and they'll still reign for 8 years after the end of your presidency, right? But also, Nixon doesn't have that power. That's crazy. His arms are in a coffin. And the fact that we know that is we know that O'Connor and Souter and Stevens didn't turn out as well as they thought, right? The same processes that said that they thought they were appointing those judges. They thought that they were getting them. But in actual fact, they're appointing judges that had their own philosophy, were going to interpret it according to precedent, and develop their legacy over time, frustrated that capacity. You changed that very character and said it was exactly your job to make sure you oppose those people, and you found the best possible way to ensure that those 8 years that you've been given on the court are best constructed for your views. You didn't think that was the way to get it. And that's what we've been saying all down the bench about the appointment process. You change that character of appointment. You make it seem just like the Secretary of State. You make it seem just like your appointments to the FEC. You make it seem like just another branch of the government that you get a certain number of appointments to, and God help you, you better not waste them, Mr. Speaker, is the message that we send to presidents. We didn't think that you should be able to calibrate that. We didn't think you should be able to make single-issue appointments. We didn't think Obama should know that he's going to have to try and get a particular policy up in a part of his term, plan for the point at which he knows he can appoint the right types of justices to make sure he can get that policy up. That makes a mockery of the Constitution. We've never heard by that type of planning and that type of politicking improve the quality of decision-making. Let's turn lastly now to the perception of the court. There are plenty of politicians who are homophobic, and that is a regrettable fact. They are in a tiny minority on the court, as we've heard right throughout this debate. There are going to be presidents, there are senators, there are members of the House of Representatives who are far louder and have far more people supporting the type of homophobic and racist views that we wanted to derive. Trying to say that people feel disenchanted with government because of homophobes in the minority on the Supreme Court misunderstands the role of that body. In particular, the harm comes when the affirmative side says people need to feel like they can change it. People need to feel like they can shift the court. No, that feeling is appropriate to the executive and the legislature because political power doesn't work so great for minorities, right? Saying that you have the power to change the character of the court to deliver the right decisions works against the type of people the court and the Constitution was set up to protect. We wanted to remove that political power and that political dynamic from the last bastion of their protection. Changing that perception of what the court is about. Saying to people, elect somebody who can stack out that court. Saying to somebody, you should be opposed to the way that court is going. Vote at the next election on the basis of it. Was exactly how you change the character of the politics of that decision and allow people to appoint people that were more political. I've just said, if approval is so high of this court vis-a-vis other arms of government, why the affirmative side wanted to radically change it to make it more like the hated branches of government was beyond me in terms of improving the quality of the perception of that court. So if you were going to improve it, we don't know why you'd make it the couple of branches of government that are actually hated more than the Supreme Court was a way to go about improving it. So, the case of the negative side is very clear. This appointment was necessary, but should be constructed in a way that minimised the political impact of that. The affirmative side could not work out what they thought about precedent, whether or not they liked it or whether or not they hated it. And they misconstrued that court in the hope that it would pass less homophobic and less racist decisions, all the while creating a political discourse that was more likely to deliver those very outcomes. And that's why we oppose.
Two questions at the end of this debate. Which process leads to better judicial outcomes? And which process is most consonant with the judicial role? So which process leads to better judicial outcomes? The affirmative team pinned their case on a number of poor judgments. DC versus Heller, Dred Scott, Justice Scalia's dissent in Lawrence versus Texas. But what was always lacking was a clear link between term limits and avoiding this list of perceived bad decisions. It was always just as likely that President Romney would appoint a fleet of Scalias to ensure that his agenda held. And so the problems of poor decisions advocated by the opposition were not inherent to the status quo. But in reality, these problems were worsened for a number of reasons. The first was that there was always a very high likelihood under the opposition plan of appointment on single issues to advance a particular president's agenda. What this meant, as we showed you, was that constitutional limits on the power of presidents were ephemeral because they could manipulate the appointment process and manipulate that appointment process in a guaranteed way to ensure that their agenda passed. What this also led to was judges that were less likely to respect precedent. As I showed you, judges always have an interest in building their legacy. But when that interest is time sensitive and is accelerated, you're more likely to have extreme decisions that weren't the best quality decisions. The affirmative team fell back a third speaker on being okay with overturning bad decisions if the political process supported that. But we showed you that there were a number of harms through that type of approach. Firstly, through undermining certainty in terms of the validity of any kind of constitutional restraints. Secondly, in terms of discrediting the legitimacy of the institution as independent from political pressures. And thirdly, in terms of creating perverse outcomes for judging. And it's on this point that we didn't get a huge amount of engagement from the opposition. We showed you that judges would be more likely to select high-profile cases or select cases in areas they were interested in or be more subject to lobbying without the sufficient disincentive, without the sufficient check of being there in the long term. That was problematic. What we also showed you was that there were existing disincentives for overreach. We pointed you to Chief Justice Roberts' decision as an example for the interest of certain judges to build sustainable coalitions over time. We said that was more likely when you didn't have a finite window of time to impose your legacy on the court. So we thought the incentives for moderation were always stronger on our side. Accelerating the departure of these judges changed that interest. But secondly, which process was most consonant with the judicial role? Right at the start of this debate, I told you that any interaction of control between the legislature and the judiciary should be minimised as much as we possibly can. To the extent that it is inevitable that presidents have to appoint judges, we wanted to minimise that, make it rare and make it accidental. The affirmative team suggested that judges needed to be receptive to social change, but we questioned whether life tenure made that impossible. We didn't believe that you're so insulated from the outside world that you couldn't understand that cars and aeroplanes exist. But importantly, we also noted that this misconceived the judicial role. There was a difference between the legislature and the judiciary on the basis that the judiciary was never a vessel for pushing a party agenda. We didn't think that the judiciary was actually capable or legitimate in guessing public opinion. So we thought that guaranteeing high turnover was harmful. We thought maximising the extent to which electoral cycles were about judicial appointments was harmful. We thought the credibility of that institution and the extent to which its decisions were accepted would be undermined once you enhance the extent of politicisation. So ultimately, if both sides accept that politicisation exists, the question was, how can we minimise that and how can we ensure the most sustainable and effective outcomes? That's where the negative team won this debate.
Mr. Speaker, both teams' models in this debate were going to generate either respect for precedent or perhaps no respect for precedent. Good decisions and bad decisions. That was not the choice between the two teams in this debate. The question was, how best do we deal with circumstances in which courts throw precedent to the wind? Well, the problem is when judges have no incentive to moderate their behaviour because they've got 30 years to entrench their position over the long period of time. If judges care about building their legacy, as we heard from all members of the negative team, then they should care about the impact of their decisions beyond the 8-year terms. If certainty is going to be undermined, that means both sides can respond to those pressures and issue decisions. We told you that the important thing is that modern day rights be determined by modern day judges, and they never answered that challenge. Two questions. Firstly, what is the role of the court and how do we improve public trust in the judicial system? Secondly, what is the real impact on decisions? The first thing we told you at the start of this debate is that it's principally illegitimate for judges who were appointed many years ago as a result of accidental deaths or various times in which they timed their retirements to control modern day rights. At various times we heard contradictory and different responses from the negative team. Firstly, we heard that if you want to protect civil rights, you don't want judges to be considering modern day approaches that would be bad if Roe versus Wade was overturned. But then we heard at third that it would be a good idea for judges not to consider those things altogether and not to take into account the impact of rights. What we said though was that when rights are going to impact modern day life and modern day decisions and people around them, you had to have control and understanding of those particular things. And as much as they wanted to say that judges know what cars are, they didn't really engage with the material that when you become on the court, you are in a different kind of environment. You are told to insulate yourself from political pressure, not to read the news as John Roberts does. And the problem we said is that it creates a disconnect between the public and society and the judicial system as a whole. The second thing we told you was that in terms of civil rights and respect for precedent, our system is better for getting the public engaged with those particular things. And second, I told you that Roe versus Wade had not led to a full acceptance of abortion rights in society because people didn't believe in that decision and you require other people to implement and protect those rights. No response from those guys. Ultimately, the right balance was struck between the legislative and judicial branches because ultimately the Supreme Court is deciding political questions. And in a system where you have bills of rights, and that bill of rights is going to affect people in the modern day, the public should be able to control those outcomes, and we didn't particularly care whether that was precedent or respect for civil rights, whichever one the public wants is particularly fine with us. Secondly, what is the impact on decisions? We told you that the problem at the moment was when you have a 30-year, 20-year, 10-year period, or however long it is until you have a corollary, you have less incentive to care about the impact of precedent, because it means you can control what precedent is in the future. Their response was that if you only have 8 years, you're just going to put in whatever changes you can get because that's your limited time on the court. If you put in those changes we told you, then that led to a public response. Those decisions would be able to be overturned by the next person. So there's a limit to which how politically you can make your decisions because public response and the precedent allows for judges to change that. We didn't particularly hate democracy as the negative team continued to do throughout this entire debate because if the public wanted those particular things changes, that was a good thing. But secondly, we told you here is that it's a better system in which there's less manipulation of the judicial process, where judges don't time their retirements to when there's a president who's a Republican or Democrat, as we told you in Charles' speech, and we got no response from them at the end of this debate. In terms of certainty and lower courts somehow getting to people what cases are heard, we told you in Alex's speech, the courts don't really get to decide what these things are. The courts care about abuse of process and don't believe the judicial system should be a function for that. No response in terms of those issues. Yeah. The final thing we told you is we actually get better judges under our system. As much as they can wave David Souter and Sam O'Connor against us, we told you that it was unlikely for people not to respond politically when it is a 30-year mandate. There'd be less politicisation and you want the best people to ensure continuing respect for the decisions that are made because you want it to survive that 8-year term. Less Harry Mees will be put up. Less John Roberts, who was at the age of 40 appointed, will be put up. And even if you lost some moderate coalition building forces, we told you that wasn't a particularly bad thing because that led to worse decisions over the long term. For these reasons, we propose.